Welcome to Building Your Legacy, Southern Arizona Estate Planning with Allison Manning.
Welcome to Building Your Legacy in Southern Arizona with attorney Allison Manning. Allison is an estate planning attorney who helps individuals and families across Southern Arizona create clear, practical plans for the future. She works closely with clients on wills, trusts, powers of attorney, and long-term care planning, with a focus on making sure those plans actually work when they're needed. I'm Lisa Mosbey, and today we're talking about some of the most common estate planning mistakes Allison sees and how families can avoid problems down the road. Welcome, Allison. Thanks for joining me.
Thanks for having me, Lisa.
Allison, what are some of the most common estate planning mistakes that you see people make?
Well, probably the most obvious one is people just not planning, not doing anything, thinking they always have more time and that they'll get to it eventually, or that it's not necessary and that they don't need to do any planning at all. But of course, with that, the other planning issues that I see are as people move to Arizona, not taking advantage of community property, being in a community property state. Many people come from states that don't have community property, and that there's some tax savings with that. Additionally, common mistakes I see are beneficiary designations not matching your estate plan. So possibly names don't match where you're saying assets go. And of course, we all know that designations on certain assets control over the documents themselves. And so those are some big mistakes that are easily fixed.
And what are the risks for waiting too long to create that estate plan?
Well, number one risk, you die before your plan's in place. So please don't do that. Don't let the truck hit you before you get your plan signed. Another risk is incapacity or illness. So you haven't made designations, you haven't said who's in charge, and now you can't because you don't have the capacity to enter into or to sign documents and designate those anymore. Additionally, another risk is if you wait too long, possibly there's claims of undue influence or that you are under misinformation, which opens your estate to some challenges after you're gone. So those are some risks that we know we see frequently. I usually encourage clients to get their plan in place well in advance of something going wrong, and we never know when that's going to happen. So getting it done early and then reviewing it regularly will help avoid problems or challenges later to your documents.
I have to say, I was unaware that an Alzheimer's diagnosis or dementia diagnosis can sometimes block somebody's ability to change those plans. What's your experience on that one?
Right. So a diagnosis really depends on a lot of situations. So it doesn't mean you can't sign new documents, but it does minimize the ability for understanding what you're signing. And so, of course, as an attorney, I have to sit with the clients and review documents and make sure that they actually understand what they're signing at the time they're signing it, make sure they understand the size of their estate, that bounty of their estate, and where assets would go naturally or who would be in charge if they didn't sign documents, and then see what they're putting in place. If you have a diagnosis, and you sign new documents, that really can open your estate plan for a challenge later on if somebody's excluded or gets a lower dollar amount than they were expecting, because your state of mind is no longer what it once was. Now, we all age, our minds do deteriorate, and we do lose memories and things. And so again, putting things in place, that diagnosis really affects it. So get that document signed ahead of time before that diagnosis. But just because you have the diagnosis doesn't mean you can't sign documents, but it might mean you can't. You might be too late, and we'll find ourselves going through the living probate process, doing a guardianship and conservatorship for you.
Thank you for clearing that up because I think I've run into some confusion with folks about that one.
Mhm.
What can go wrong when someone creates documents online? That's another one I've passed online without legal guidance. What do we do?
Yeah. So that legal guidance, people underestimate the importance of sitting down face to face with someone, answering questions about what's happening in their life. So that way your document choice, the selection, whether it's a will plan or a trust plan, or whether we have some special provisions in there, those are things that get missed when people use online programs and aren't able to actually have a consultation on what is needed. It's not always a one size fits all. It's not a, hey, you need this type of trust. I did have a client who built one online and didn't put in provisions for their special needs child. And that special needs child ended up receiving an inheritance that disqualified them from some government benefits. And we had to do several things to put things in place and get those benefits back for them. And again, that was because they were trying to save some money. They missed out on a few opportunities that ended up costing a lot of money and a lot of headache later on.
So, what mistakes do people make when they move to Arizona without estate planning documents from another state?
So, first, we want to make sure that your estate planning documents comply with Arizona law and that they meet the standard, especially for a will. We want it to be a self proving will so we can go through an informal probate versus a formal probate and have to prove up the will. A lot of states don't require the same witnessing and the notary witnessing there, that the witnesses are also notarized as well. The one thing I see frequently with married couples is they'll have separate estate plans because they come from a state that doesn't have community property. Their assets are divided into two trusts, and we don't get to take advantage of the ability to get 100% step up in basis on the death of the first spouse because they don't have community property of their assets. They have things held either jointly or they have them held in separate trusts. And so if we take advantage of that, we have clients who've moved here sign community property agreements and do a community property trust. That really will help avoid some problems and save some money for family members. Additionally, we do have just some different documents, such as the mental health power of attorney in Arizona that many states don't have. It's an important tool that if you needed to go into a psychiatric hospital or partial hospitalization for treatment for mental health, if we have you sign a form that says your agents can sign those paperworks and get you admitted for it, we don't have to go to court. But if you don't have that document, we're going to court in order to get permission to get you admitted for treatment you need. And so again, it's a document that we don't see in a lot of other states.
I'm thinking about the problems that arise from beneficiary designations that do not match the rest of the estate plan. Um, what happens in those cases? How do you correct that?
So, how do you correct it? Hopefully, you catch it before they pass away, because if they don't match after you pass away, you may not be able to correct that. I did have a client who had named his children as beneficiaries on a brokerage account 50-50 instead of putting that account into his trust. His trust divided the estate 80-20 between the two children because the one daughter took care of him, lived with him, helped him out, had given up her career to help him in his final years, so he wanted to leave her more money. His main asset was a brokerage account that wasn't properly funded and had beneficiary designations 50-50. And so it did not go 80-20. It went 50-50 between the two children. So again, that designations, we need to catch that in the estate planning process. When we are putting the documents together, when we are funding the estate plan, so making sure assets are properly transferred from your name into the name of your trust, that would help avoid having payable on deaths that bypass your plan, because those are going to control the designations on your accounts, are going to control over what your trust or your will plan says.
And thank you again for clarifying that because that's often overlooked. There's so many nuances here that we miss out on when we're trying to do this on our own. What mistakes do people make when choosing trustees, agents, or other decision makers for them?
So many times, one, people don't update their agents and their successor trustees. They pick someone 20 years ago and they never looked at their documents. And so they, instead of having their children, which might be the natural successor to you on those documents, they still have their parent or their sibling who has since passed away as well. That's a big mistake. Another mistake that I do see is that people oftentimes use birth order. And they say, I'm going to put my oldest child, then the next, and then my youngest in that order. And that's not always the right scenario. Sometimes the oldest child isn't around. They live somewhere further away, or they're busy in their occupation, or they have young children and they can't be there to help. It's not always a birth order thing or a gender designation of the oldest daughter or the oldest son gets to be in it. I really encourage people to look for the right person who's able to follow your wishes and that has the time and the ability to do so. It's not always geographical, but sometimes it is. If there's a tie between two children, sometimes you go with the one that's closest versus the one that lives further away because they can be here to do some of the work. Additionally, sometimes it's not a family member. When we know that children don't get along, don't name your children to be successor agents, and especially don't name them to be co agents together. Possibly use a third party, a fiduciary, a lawyer, a CPA to be in that role and be able to navigate between the dynamics of the family.
And then, Allison, what can happen when someone creates an estate plan but never properly funds their trust?
That is a can be a big problem. So funding your trust is the process when you take assets from your name and you put them in the name of your trust, or you beneficiary designate them to your trust upon your death. That process, it can find that your family will end up going through the court system in order and use your will in order to get it into the trust, because you will have then passed away with that asset in your name, and it doesn't follow the guidelines of what your trust says. Your trust doesn't own it. And so the court system is the only institution after you die that can transfer the asset from your name to the name of your beneficiaries, which oftentimes is your trust through a pour over will, or if you have a will plan, through to down to your beneficiaries in your will. So we need to make sure that we designate them properly, change the title to the name of your trust. And as we had talked about, the beneficiary designations on assets go around the trust. And so I usually recommend naming the trust as your beneficiary in most situations. If your trust has the right retirement language and certain language in there, get it into the trust. Then you only ever have to worry about updating your trust. You don't have to go around to all the different assets and redesignate those if your beneficiary percentages change or your beneficiaries change.
I have no doubt that you've run into poor communications issues between family members um, after someone passes away or becomes incapacitated. How do you handle that when there's poor communication involved?
So I encourage my clients to have a family meeting, having that family meeting while they're alive, if they're open to it and if they think it would be helpful. If it's going to cause more problems, then, let's not, we'll worry about it later. But it really helps the children understand the dynamics of what's happening. I had a client who told his daughter, who lived here locally, that after he died, she was in charge of everything. His wife had dementia, and the daughter was very involved in taking care of the mother, and the father passed away suddenly. Unfortunately, he hadn't been truthful with her. And it was actually the other child that lived in another state who was in charge of everything after he passed away because he wanted to avoid conflicts. What happened between the siblings was it created a huge wedge between them and a division at a time where they really needed to support each other and help each other through it. So those miscommunications or those little white lies, so that because you don't want to tell somebody the bad news that they're not in charge of your estate, causes worse problems and doesn't bring family members closer together, but may cause family members to never speak again, which is what happened in this situation. And it's extremely sad to be a part of that and see that this family just missed the mark in their planning because, again, they both need to be there for their surviving mother.
And we all know so many situations where families become estranged after the loss of a loved one. It happens more often than it should, but that's why we have you in this place to be able to help us sort through it.
That's right.
Uh, how often should somebody sort through their estate plan, revisit it? What kinds of life situations need to occur for us to actually, again, review our estate plan?
So I recommend clients review your plan every 2 to 3 years. I send out letters to my clients and have them come in to do that review. But if a life change, a death, a divorce, or a diagnosis comes along, those are times where I encourage clients to reach out to me. And so that way we can revisit your plan and make sure that your plan works when you need it to work. Because we know a well drafted plan that's up to date can actually avoid conflict and can draw family closer together and can help pass your legacy down in a meaningful manner.
Very true. These aren't things we want to be thinking about when we'd rather be with our loved one or grieving. Any final thoughts for the audience today on this subject?
I just think it's really important to take care of your planning now. Don't wait for tomorrow because we're not promised tomorrow. So take care of it now. Help your family out and talk with them about it. Let them know what your wishes are. Children usually want to honor your wishes, they just don't know what it is. So if I can do anything to help you with that, happy to talk through your concerns.
Thank you, Allison. This has been fabulous and very eye opening for me, and I'm sure the audience enjoyed it as well.
Thank you so much, Lisa.
That's it for today's episode of Building Your Legacy in Southern Arizona with Allison Manning. To learn more or get guidance for your specific situation, you can visit AllisonManningLaw.com. Thank you so much for listening. Don't forget to like, leave a review, and subscribe to the show. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.